Give the land back to the Indians. Hi, I'm Scott Ott, and this is Bill Whittle Now. And Bill, that's what the Supreme Court just ruled, in effect, in a 5-4 decision that a tribal group that sued the state of Oklahoma, asking that federal treaties with the Native Americans be honored, has triumphed, actually, thanks to Supreme Court Associate Justice Neil Gorsuch, who voted with the so-called liberals on the court, Sonia Sotomayor, Ruth Bader Ginsburg, Elena Kagan, and Stephen Breyer, and essentially said this. The question came down to whether the Creek Indian Reservation continued to exist after Oklahoma became a state, or whether the previous arrangement with the federal government persisted. And Gorsuch wrote in his majority opinion, because Congress has not said otherwise, we hold the government, meaning the federal government, to its word. Now, Bill, this doesn't mean that the land itself is now the property of the tribe, but that the tribe enjoys jurisdiction within what amounts to about half of the land in Oklahoma and some of that in Tulsa. Bill, is it about time that the federal government lived up to its obligations to the Native tribes?
Well, I just want to say that this is a time when our traditional culture is being pulled down on all fronts, and I'm fully aware of that. But I'm with Neil Gorsuch on this one. I'm with Neil Gorsuch on this one for the simple, most fundamental reason, and that is when you have a contract, you enter into an agreement, and if you don't live up to that end of that agreement, then you can't complain that you signed the agreement. We have a long and troubled history of having reneged on treaties with Indians, and these treaties not only brought peace during the settlement of the Old West, but these were essentially, if you'll pardon the expression, I don't know what else to use, these were white men's tools. These were white men's agreements in their language and in their law system that the Indians agreed to and signed, and the people who knew better, the representatives of the U.S. government, also signed, and those treaties need to be respected. And that, to me, that's a timeless, nationless, fundamental philosophical and moral truth.
The tribal groups actually, Bill, refer to these treaties in ways that you typically hear conservatives and constitutionalists talking about our founding documents. They say that these treaties are sacred.
Yes. Look, I don't want to define down sacred in the way that hero and genius and so on have been defined down. But essentially all contracts, all promises have a degree of divinity in them, to the degree that you are making a promise, you are putting your character on the line, and you are signing a document that basically says, I will agree to do this. The document can't make you do it. It can provide consequences if you don't, but it can't make you do it. And when you're talking about documents that basically determine the future of an entire people, your people, in the case of these Indians who signed these documents originally. Yes, that is a sacred obligation. And one of the things I've tried to do with this channel and working with you and Steve and so on is not to expunge the sins of America, but to at very least to put them into some kind of perspective and to make it clear what was actually happening at the time and how things have improved and continue to improve. And this particular area, in other words, Scott, I know this is a strange thing to say, but if you're at war with Indians, war is war. And that's what it was. It was a 300-400 year running war. But a treaty, a peace treaty is a solemn, sacred document. It's not a junk bond. And of all the things in our history that I think are certainly less than exemplary, that can be repaired. And this is the thing. There's so much of history that cannot be repaired, that cannot be undone. But unlike, for example, it's a good example, unlike reparations, the idea of reparations for slavery, to me, doesn't hold any water, because slavery's been abolished for 140 years and we're 7 generations away from slaves now. But this law affects Indians today. It affects their people today. It affects their nation today. It is a long overdue obligation that the government of the United States did not live up to, and has the potential to, and it looks like they finally have.
Now, the key area where this case is going to make a difference comes in criminal prosecutions. In fact, the case called McGirt versus Oklahoma arose because of a particular character, a Mr. McGirt, who was an enrolled member of the Seminole Nation of Oklahoma, and he was convicted of sex crimes against a child on Creek land. In the post-conviction proceedings, McGirt argued that the state of Oklahoma, lacked jurisdiction in the case and that he must be retried in federal court. Bill, this is another one of those situations where something you value is upheld by something you despise, is it not?
It is. And I have to tell you, I am not nearly as well informed about the niceties of how these two legal systems function to be able to comment on that with any intelligence or confidence. That hasn't stopped me in the past, however. But
I guess what I'm just asking is, like, does that make any? Because John Roberts' argument was, Chief Justice John Roberts, who wrote with the minority, basically said, look, this case not only is going to affect prosecutions going forward, meaning the state of Oklahoma won't have jurisdiction within the native reservation, but that it will affect cases behind us, because people who were convicted under state law could say, look, the state didn't have jurisdiction there. We need to retry this case. And so Roberts' argument seemed to be premised upon the idea that, well, it's one thing to honor a treaty, but it's quite another thing to go back and have to retry cases that have already been settled.
Well, let's separate these two issues. One issue is, and I'm going to just make this as impersonal as we can just to understand it. If you have what we have at least in some form with Indian nations in America inside the continental U.S., we have a nation within a nation. That nation within a nation has a certain degree of autonomy, has a certain degree of its own laws, tax rules, and so on and so on and so on. So the big question is, if the person in the nation within the nation commits a crime major enough that extends across the entire overnation, the federal government of the United States, does the federal government have a moral obligation to go in there and to prosecute for that crime if the local Indian government does not? And my feeling is that since murder, rape, arson, stealing are universal human vices, that to presume that a court that was comprised of people in the case of the Indian nation wouldn't be able to render justice. Look, there's lots of cases where justice isn't rendered, so I don't think we do have the right to go in and do that unless the crime is committed against people who are not members of that nation. By we, do you mean the state or the federal government? Because the tribes, as you pointed out, the tribes will still handle most minor cases, but it's just when they get to things like murder, for example, or child rape in this particular case, where the federal government would have jurisdiction. Well, federal government or the state government, I don't understand the niceties.
This ruling says the state government does not have jurisdiction.
Well, my point is that I don't think I would have to be presented with an extremely egregious case to even consider whether or not the state or the federal government has the right to interfere in the legal proceedings of what goes on inside I'm sorry, it wasn't the Cherokee, was it?
Actually, there were four tribes. This in particular one is referred to as the Creek or Muskogee Indians.
Okay, so if the Creek and Muskogeans have
the defendant, that's who the case was decided in favor of, or that's where the spokesman that we hear from come from. Seminole was the tribal affiliation of the guy who was, of McGirt, who was in this case. Sorry.
Having attended the University of Florida, I can say that any laws that can be brought against Seminoles, I think I'm in 100% favor of. They're a low-life bunch of worthless skellowags.
Keep your cards and letters coming, folks. Go ahead, Bill.
Again, the agreement was that they would have their own laws, and I think that we need to respect that agreement. I think an exemption would be if a crime was committed against a member against a person who was not a member of the tribe. Then I think then I think suddenly the state government or the federal government has skin in the game, so to speak. But to say that a tribal legal system, a tribal judicial system, would just simply say, child rape, nothing to worry about. I just find that impossible to believe. Now, this may be an individual miscarriage of justice in this case, but miscarriages of justice happen all the time. And we have an obligation and we have a contract with these people. Now, as far as Justice Roberts' concern that we go back and undo all these things, he does seem to have a particular obsession with this particular aspect of things. To the degree that cases are still open, I think you probably could, because we're not talking about, huge numbers of cases. If this law was in effect, let's say, I don't know the date, I'm going to make it up. In 1880, we signed an agreement, and I'm going to make this up too, with the Creek Indians. And we said that during that treaty that they would have their own internal government and their own internal laws and so on, jurisdiction, all of that. If we made that agreement and signed it, and they signed it, and it's taken 140 years for them, for the United States to live up to its end of that treaty obligation, then yes, I think that cases would need to be examined. You can't unexamine and undo cases of people that have already died, and that is certainly the case here. But how many cases are we talking about? I mean, it's certainly an achievable number.
Well, the implication is that people like McGirt would say, hey, my conviction, because the whole appeal that generated the Supreme Court case happened post-conviction of McGirt. So that people who have already been convicted of crimes could say, look, Oklahoma did not have the jurisdiction to convict me of that murder. I demand to be retried in a federal court.
You're talking about people who have no connection to Indian
No, they have
affairs
to be.
at all?
They have to be a Native American. But I'm saying within that, in that context, they could, Native Americans who've committed, let's just call them federal crimes, but got convicted under state courts could now say, look, that was a violation of our treaty obligation. The Supreme Court of the United States has upheld that treaty obligation. I deserve to be retried in a federal court. I get another bite at the apple, so to speak.
They deserve to be retried not in a federal court. They deserve to be retried, if I understand correctly.
Well, certain serious crimes are will be tried in federal courts under the treaty. The Native Americans handle most of the lower level crimes, but it's the very serious crimes that there's a small subset of those that are handled by federal courts under the treaty. So under the treaty, there is a provision for particularly egregious crimes to be handled in federal court. And the argument is that since the U.S. government had not agreed to it officially, that but that's nonsense. No. The argument is that Oklahoma has been acting for years as if once Oklahoma declared statehood, then they became sovereign in that area. And the Native Americans are arguing, and successfully before the Supreme Court, no, the sovereignty that we enjoyed in most cases underneath the treaty still hold, and the federal government is the locus of responsibility or jurisdiction for these egregious crimes.
Well, as we're discussing this and thinking it through in real time, I have no idea what's coming, as we've said many times. I think, I don't want people to get people who've been fairly convicted, I don't want them to get another chance to go free, but then I immediately arrest myself and say one of the foundational principles of our society and our civilization is the presumption of innocence. And if you are saying that there's even if it's a technical loophole that provides an opportunity for somebody to get a trial that they may feel have been prejudiced because of whatever reason, then I think they should be entitled to the retrial. If there was enough evidence to convict them in the first place, there should be enough evidence to convict them again. We're not talking about a huge amount of social work here, but we are talking about a chance to live up to obligations that we made 140 years ago and continue in the ongoing process of improving this country and getting it ever closer to the ideals that it originally was based upon, and which we will never achieve, being human beings made out of flesh and blood. But nevertheless, the direction has always been towards more justice, more freedom for more people, more extension of these fundamental, inalienable rights. And if it turns out that there is a case to be made that the state of Oklahoma acted in a way as if they owned these lands or had jurisdiction over these lands when, according to a treaty that the United States government signed, they did not, then I think that's absolutely grounds to retry the case. And again, if there's enough evidence to convict in the first place, I don't think we're going to see a great deal of miscarriage of justice here. The larger justice, is to live up to the obligations of people who agreed to lay down their arms and to, in many cases, completely relocate their entire society based on the fact that they were faced with overwhelming military force, and that military force, in its own language, using its own legal system, agreed that we would stop the fighting under these conditions, and these tribes made this agreement, signed it, and to not honor these obligations is disgraceful.
The members of BillWhittle.com have made this program possible. I was just once again this morning reading through the member blog and realized that I'm not a big blog reader, but this one's pretty good. I am often taken aback by the mental acuity and ability of expression of our members as they create their own content at BillWhittle.com. Of course, you can only see that if you're a member at BillWhittle.com, which is the whole point of what I'm saying now. Why not give it a try? Go to BillWhittle.com and click that big green Become a Member button and find out what you're missing. For Bill Whittle, I'm Scott Ott. Thanks for watching.